Okay, in this video, we're gonna talk a little bit about haters, and haters are people who don't want you to have something just because, even though it may or may not impact them. And I don't know. I guess this impacts them, but not really. We're gonna talk about the Supreme Court and why the Supreme Court they hate student loan forgiveness. They are not in favor of student loan forgiveness, and they had oral arguments this week to address the multitude of litigations. There's 2 or 3 cases going on around student loan forgiveness, and just from their line of questioning, I'm gonna tell y'all, I don't think it's gonna fly. And just from their line of questioning, I just don't think it's looking good for student loan forgiveness. Now, before we dive in, I always gotta give the caveat. I'm a licensed attorney, but I'm not your attorney, so this isn't legal or financial advice. Just letting y'all know what's going on, giving my opinions on takes and topics and attorney reactions. Now, we got to start with a little background information so we can understand this process. Because I tried to live stream and do it, but those dudes were in court for 4 hours. 4 hours. Hey, I love y'all, but there's no way in the world I'm going to be on here 4 hours listening to some oral arguments. Because, hey, it's really not that exciting. So that's definitely not going to happen. But I wanted to give y'all a short, nice, compact version of what happened, what are my thoughts and opinions. Now, when we talk about a case getting to the Supreme Court, at this level, this is essentially where the big boys come to play. I've never been a clerk for a justice on the Supreme Court, but I have been a clerk for a justice or for a judge on the federal court who's a hop, skip, and a step away from the Supreme Court. I've been a clerk for justices on the Supreme Court at the state level, so I know a little bit about the process. Essentially, what you have when a case gets to this level, you have parties who've been through litigation, and the courts either made decisions or they kicked it upstairs for the Supreme Court to hear. Now that it's at the Supreme Court, you have party A, they'll submit their brief to the court saying, this is what's going on, this is what should happen, this is our law and justification for why things should be ruled in our favor. The opposing side submits their brief, and behind closed doors, the clerks, the justices, they read the briefs and they write an opinion. Based on what we see from both of the parties, we think that we should rule in this favor. A lot of times oral arguments don't happen because they make their opinions based solely on the briefs that are submitted by the parties. But if it's a controversial issue, if it's an issue that they may have questions on, then you'll see the court grant people oral arguments to give you time to argue your cases. So that's just what it is from a process standpoint. We got to also look at the makeup of the court. Judges, justices, all of that, those guys who wear the black robes and everything, they are not supposed to be partisan, okay? But it's not supposed to be a party affiliation. It's not supposed to be a conservative, a liberal. It's supposed to be guys wearing their robe who decide and call it like an umpire. This is a strike, this is a foul, this is a fair ball. But that's not realistic. We got to be realistic with how things go on. Right now, the court has a conservative majority. 6 of the justices are conservatives. Chief Justice Roberts he leans towards the conservative side, but not the most harsh, strict conservative. But we have to understand the makeup of the court. Now that the court system is a little bit more conservative, we got conservative majority, now it gives us some insight into how they're going to rule. Okay, this is what was at issue with student loans. Now, there were multiple lawsuits. A couple of the lawsuits are going to get thrown out because the party doesn't have standing. What is standing? Standing is the ability to make sure the right person is in court suing because they suffered some type of harm. Here's an example. If I see my aunt get rear-ended and I'm sitting on the porch watching her, she gets rear-ended. And she's like, oh, I got some damage to my car, but I'm not even going to worry about it. Next day, her neck hurt and she all broke up, but she never wants to go to court, do anything about it. I go to court, sue on her behalf. the case is going to get thrown out because I don't have any standing. I'm not the right person to be in front of the court. She has to be in front of the court. I don't have any harm. She's the one who suffered the harm. Only times where you see people can fill in for another person and not violate standing is essentially if it's a minor child, the parents can sue on behalf of the child, or if it's a lawsuit where a person passes away, their estate may have some legal recourse. So a couple of the lawsuits are going to get tossed out from standing. A lot of the lawsuits filed by the state. There were one lawsuit filed by two petitioners, Brown and Taylor. Brown doesn't have standing because he has no harm. Brown's argument essentially was that he should get this student loan thing should be tossed out because he can't get his loans forgiven because his loans are private loans and not government loans. No standing. You don't have any harm. How is this impacting you? His probably going to be tossed out. Taylor is unique and stupid in the argument. Taylor's argument is that I only qualify for the $10,000 student loan. I don't qualify for the $20,000 forgiveness because I don't have a Pell Grant. He has no harm. What is the harm you suffer? If this passes, your loan will decrease by $10,000. His argument is that, no, I don't want it to decrease. I don't want nobody to get it. No, that lawsuit was just pushed by some organization who had some money to file a lawsuit on his behalf. So I think those two are going to get tossed out, so we aren't really worried about those. The major question at issue is called the Major Questions Doctrine. Now, we got to understand, before I talk about what the Major Questions Doctrine is, anytime you hear the word doctrine and a court talking about doctrine, just think of make-believe. It's made up. Doctrine is made up. The Major Questions Doctrine is a made-up doctrine. What do you mean it's made up, DFD? How does that make sense? Why would the court make it up? Okay, Congress passes a law. Now that Congress passed the law, because they never write their laws clear, there's some question as to how that law should be interpreted. Lawsuits get filed, it goes through the court system, it makes its way to the Supreme Court. The Supreme Court will create a doctrine and use that doctrine as a basis for why their analysis of that statute is correct. So the Major Questions Doctrine was a doctrine not made by statute or law. It was made by the courts to allow them to help them make a decision. Where did we see this doctrine? Where have we seen this doctrine come up? Well, let's just think back. During the pandemic, mortgage moratorium. The Center for Disease Control wanted to institute a mortgage moratorium, but the Major Questions Doctrine barred them from actually implementing a mortgage moratorium. The Major Question Doctrine, in short, says that anytime there is a question or issue that's a major political concern, major political talk is popular, both sides want to argue over it, anytime it's a major political concern or it's an issue of monetary value, a lot of money is at play, that's a major question that should be addressed by Congress. And you got to think of it. You got the executive branch, legislative branch, and judicial. The Major Questions Doctrine is just something they came up with to try to make sure power is balanced and that the executive branch, Congress, the EPA, whatever these government agencies are, don't overreach or have too much power. So that's the Major Questions Doctrine. That was an example of when the Major Question Doctrine was actually used. So right now, what the court is saying, the court is essentially saying that, hey, this implements the Major Question Doctrine. This is of high political concern, and there's a lot of money at issue. Because if $10,000 and $20,000 of student loan forgiveness, if it becomes law, if it goes through, if the justices say it's okay, we're talking about $400 billion. That's what it's going to cost for $20,000 and $10,000 of student loans to be wiped out across the nation. $400 billion. Now, it's interesting because Chief Justice Roberts actually also brought up a separation of powers argument. Chief Justice Roberts expressly said that President Biden and the executive branch exceeded their authority when they made this decision unilaterally without input from Congress. So it's going to be interesting to see how this plays out. Now that we talked about the separation of powers, now that we talked about the major questions doctrine and why the conservative justices said that this implicates the major question doctrine and it should be something Congress handles, that's what they were alluding to in their question. Justice Kagan, who's a liberal justice, actually had a really good argument. President Biden and the executive branch waived and forgiven student loans based on the HEROES Act, the Higher Education Relief Act that was passed, okay? The HEROES Act has express language, and I talked about this before because I think that the language authorizes the President and the Secretary of Education to waive or modify any type of contractual obligation owed to the government. But the HEROES Act has expressed language that essentially says, and I'm paraphrasing because I don't have it right in front of me, but it essentially says that, hey, the President and the Secretary have the authority to waive or modify any contractual obligation owed to the government. This is talking about education because we're talking about the Higher Education Act. Any contractual obligation owed to the government by a debtor due to a war, a military campaign, or a national disaster, a national emergency. And that last part is pivotal. I think that language is clear. I think that modification, a waiver of a government contract within the Department of Education, I think that, to me, on its face, when I just read that, I think that the executive branch is within their authority. But the Supreme Court is leaning otherwise. Now, here is an interesting argument, though, because I got to give credit to President Biden's attorneys, the Solicitor General, who argued this point, because the conservative justices, the opposing parties, were essentially saying that this is something that Congress should do. Congress should be able to have to make this determination because there's a lot of money at play. Let's think about this. This is coming from the conservative justices. This is coming from the people arguing against student loan forgiveness. What president implemented a national emergency? Who declared a national emergency? It was President Trump. If President Trump declared a national emergency, he used the HEROES Act, where a person can waive or modify a contract with the Department of Education for war campaign, or a national emergency. He declared a national emergency. He used that same law to freeze student loan payments, freeze student loan interest, and that cost $100 billion. And he did not have to seek the approval of Congress. No one ever brought it up. So now that they want to use that same law, and the president now, Biden, wants to use that same law to waive student loan forgiveness, which is going to cost $400 billion, now it's an issue. I don't see the consistency there. I thought that was a good point that was brought up by the liberal justice. Now, that's kind of where we are. Now, I know there's going to be some people who watch this video and say, oh, I had student loans in 1972 and it was $2,000 and I paid mine off, so you should pay yours off. I'm not a pocket watcher. Hey, to each his own. I'm not going to get it, but I don't care. I'm going to just pay mine off because it was my obligation. But if you get it, if you qualify for it, hey, God bless you if it passes. But there was a fairness argument that was brought up by Neil Gorsuch, and we got to talk about this. Because the fairness argument is what a lot of people are going to argue, and it does have some validity. Wait a minute. You want to spend $400 billion for a certain class of people who got student loans, where there are other people who won't get it because they won't qualify financially, or people who just paid off their student loans. Where is the fairness in that? And that was Justice Neil Gorsuch's point. And this was odd because that fairness argument wasn't in the party's brief. He brought that up unilaterally, which is never done. No, judges do not make up a way for a party to win a case. If you can't articulate a way to win your case, it's not the judge's, it's not the clerk's job to come up with an argument for you. Neil Gorsuch gave him an argument on this fairness prong, which I can understand. A lot of people have emotional ties to it, but I don't think it's of any major consequence. But more importantly, I think Neil Gorsuch is the incorrect justice to give a fairness argument. Now, this is a little background information, and it's called the Ice Trucker case. Neil Gorsuch was a judge on the Court of Appeals. When you're at a Court of Appeals, cases come before that court. 3 judges make a decision, and however the majority go, that's what happens. Here are the facts. It was a man, I can't think of his name, but he used to work in photography or graphic design, and during 2008, the housing crash, he lost his job. In 2009, he essentially became an ice road trucker. He was driving, making a delivery in rural Illinois. It was like negative 27 degrees outside. Because it was so cold, the brakes on his truck locked up and he couldn't move. So he was stuck in his vehicle. So he radioed to his company. I can't recall the company's name, but you can actually Google this case. He called the company. The company told him, stand by, we'll have someone there in an hour. Well, the way that truck was designed, the engine wasn't made to idle. So the engine could not idle, so it was cold as hell in there. So this guy put his blanket on, he crawls in his cab, he takes a nap in the cab in the bed of the truck. When he gets out, wakes up, 3 hours go by. He can't feel his legs, he's blue, he's numb. He called one of his family members. His family member said he could barely talk. And so when he radioed back to the company said, you can either try to drive to make it to the next stop, or you can wait for help to arrive. So the guy was like, man, that's not an option. I'm not going to make it. I'm running on fumes. I don't even got any gas. And the reason he didn't have a lot of gas was because the company gave him the wrong directions related to the next fueling station. So that's why he was running on fumes. So once he got that information, this guy decided to drop his trailer with all the meat that he was supposed to deliver on it. He actually got in the truck, brakes locked and all, and forced his way down the road, 5 to 10 miles down the road, where he was able to find a gas station. After about an hour of warming up and everything, he came back to the truck. He saw the repairman there, hooked the truck up to the trailer, towed the meat where he belonged. When he got back to work, they fired him for abandoning the payload. He wasn't supposed to leave the goods. He abandoned the goods. They fired him. This case came before the appellate court that Neil Gorsuch sat on. And 2 of the judges on the panel ruled in his favor because it makes sense. This is survive or die. You don't have to stay in the truck with the goods because the company told you if your life is in danger. And there was a law out there to support this. But there was a dissent. There was someone who disagreed, and essentially that was Neil Gorsuch. Neil Gorsuch said, no, the company should not be liable for his termination because he had an obligation to do this into the bargain. Essentially, his point was, hey, if they gave you instructions to stay there, you better not drop that payload. I don't care what happens. So, hey, I just don't think he was the right person to bring up a fairness argument when we look at his track record. Long story short, major questions doctrine. The court is leaning towards, hey, President, you don't have the unilateral authority to do this because there's a lot of money, it's a polarizing issue, and this has to be addressed by Congress. So I personally don't think it's going to happen. Y'all let me know what y'all think in the comments. I hope it happens, but I don't think it's going to happen. That's it. That's my take. If you enjoyed this video, check out the video on the screen. There's going to be more content related to finances and attorney reactions.